Good evening and welcome to the October 18th meeting of the Zoning Board of Appeals. Calling this meeting to order, I'll first ask the public to please silence your cell phones, and I'll introduce the board at this time. To my far right, your far left, is Jerry Patamas. He is an associate member of the board. Followed by him, we have Kim Beelen, who is the clerk of the board. My name is Terrence Hurry. I'm the chairman of the board. To my left is Ed Van Kuren. He is a full voting member of the board, followed by Paul Murphy, who is a full voting member of the board, and Bob Dugan, who is an associate member. Also with us tonight is Sari Boudreau, who is the zoning administrator, and Joe Robbins, our recording secretary. The Zoning Board of Appeals is charged with applying the zoning bylaws for the town and considers requests for special permits, variances, and appeals as provided in the bylaws, which have been approved by town meeting and the Attorney General's office for the Commonwealth. All decisions made by the board are made through the public hearing process. Our goal is to hear testimony from the applicants and the public, and also to allow full and fair discussion of the project prior to rendering a decision. To begin each hearing, the clerk will read the public announcement of the hearing and present any pertinent information from the file, such as referrals from town departments and summarizing correspondences to the board. The applicant or the applicant's representative will have 15 minutes to make a presentation, and then time may be extended by vote of the board if we deem it necessary. The board will then ask questions to the applicant, and then we will ask the public to provide any comment. Public comments should be directed at the project itself. I also ask that you please refrain from making any personal or derogatory statements. Any comments can include an opinion in favor or in opposition, or it just may simply be a question about the nature of the project. The chair will limit discussion in the interest of time if comments become repetitive. All members of the public wishing to speak should wait to be recognized by the chair and should come to the podium, and please state your name and address for the record. We usually limit public comment to 2 minutes per person, and all questions, comments, concerns should be directed to the board, and then we'll get the answer from the applicant or the applicant's representative. We will then determine if we're satisfied that we've received enough information presented by testimony and in the file. If we have enough to make a decision by motion and vote of the board, the hearing will close. And the alternative, we may continue the hearing to a future date and time certain. After the hearing is closed, no more testimony can be taken. The board may then further discuss the project among ourselves, and a motion to deny or approve will be made and voted upon. The motion will include a summary of key findings and conditions. An affirmative vote of 4 members, which is a supermajority, is required for approval of motions on special permits, variances, and appeals. A split vote, such as a 3-2 vote, is a failure to carry and would result in a denial of the project. Under Massachusetts general law, if a special permit is denied, the applicant cannot return to the board for 2 years unless the project is substantially different than what was previously presented to us. Turning to the agenda, we have 1 continuation for the night. We also have 4 new hearings, and we have open meeting items. So we will get started with continuation, application 66-18 Rogers, 689 Gifford Street.
Mr. Chairman, Mr. Rogers sent me an email earlier today.
Mm-hmm.
He is still tied up in the planning board, and he's requesting a continuation to November 1st. So if the board would please allow that, make a vote.
Okay, would anyone
It is 6:30, I believe, on 6 p.m. November 6:30. We have executive session at 6.
Would anyone like to make that motion?
I'll make the motion to extend the hearing on 066-18 till November 1 at 6:30.
Thank you.
Here at Town Hall, is there a second?
Second.
Okay, motion is made to continue application 66-18 Rogers, 689 Gifford Street to November 1st, 2018, 6:30 here at Town Hall.
Thank you.
All those in favor?
Aye.
Any opposed?
I'm abstaining. I'm not sitting on that hearing.
Okay, 1 abstention. Moving on to new hearings, we have application 65-18 Chaves, which I'm sure someone will correct me on the pronunciation, 27 Hatch Road in Falmouth.
Okay. Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Massachusetts General Laws, you are hereby notified that Jose F. Chavez of Falmouth, Mass., that way we're covering our bases, TJ, we pronounced it both ways, applied to the zoning board of appeals for a special permit pursuant to Section 240-69E of the Code of Falmouth to construct an attached two-car garage with habitable space above exceeding 20% lot coverage by structures on subject property known as 27 Hatch Road, Falmouth, Massachusetts. And for referrals, we have, engineering had its standard comment. We recommend adding dry wells, rain garden, or other stormwater measure for the roof. Scott Schluter of the engineering department stated full disclosure, our engineering inspector, Chris Bennett, is the abutter to the southwest of this lot. The driveway permit application will be handled by other staff, including approval and inspections. My review was made independently from Chris's knowledge. Concom had no comment. Health said no increase in bedroom count, okay. Fire department had no comment. Water had no comment. Assessors had no comment, and planning had no comment.
There's no correspondence. Mr. Chairman, would you please designate an alternate until Mr. Foreman gets here?
Sure, that'll be Bob.
Thank you.
Okay, and for the applicant?
My wife and I are proposing a two-car garage with living space up above. We just want to maintain total bedrooms that the house originally had. We designed a little bit, so it kind of changed the concept of the house, so that's what we're applying for.
Turn it to board questions. Bob, do you want to start us off?
I have no questions.
Paul, anything?
No, I have no questions.
Ed?
No question.
Kim?
Can you ask Jerry first?
Sure. Jerry, any
No
questions?
question.
Oh, that was quick.
I can say it slower.
Please.
Okay, so, I will have questions. So it's 3 bedrooms right now, staying 3 bedrooms, or is it,
Originally, it's a 4-bedroom home.
okay. And it's staying 4 bedrooms?
Yes,
I just didn't see the other 2. So you have the 2 over the garage, one, I saw the master on the main floor, where's the other one?
it's on the far corner of the house.
I just probably didn't print the second floor plan. Okay, so it's 4 bedrooms remaining, 4
Yes.
bedrooms, okay. And then that includes the 2 above the garage.
Correct.
And there's a pass-through, is that kind of true? You have to walk through one bedroom to get to the other?
No, there will be a hallway,
Oh, okay.
or whatever you want to call it.
And then is the addition taller than the existing house?
Yes.
What's the height of the addition?
I think it's on the layout. I don't have it on my notes.
28.6.
Okay,
But I believe it's an email. I don't, because it wasn't on the elevations.
right,
So I believe it's in the file in an email.
okay. And no basement under the proposed garage?
No.
Is there a basement in the existing house?
Yes,
What's that, is it finished or unfinished?
unfinished. There's crawl space / basement combined.
Okay, that's all I had for right now.
Regarding the engineering comment regarding drain water, are you amenable to placing any dry wells on the addition?
I'm wide open to introduce dry wells.
And as a condition, we usually include language that your own engineer would determine how many and where they would be suitable.
Okay.
That's all I had for questions. Any other questions from the board? Sari, any questions?
No, I think the board, when they determine the drainage, it should definitely be conditioned at the addition, and preferably on like the southwest corner, so there's no runoff into the neighbor's yard. The discretion can be up to the engineer, but I did talk to Mr. Chavez briefly about it.
Okay.
And he is amenable. And the sheds are remaining.
I have a question about that.
There's lot coverage calculations, I believe, in the file.
Of course, I'm asking about the sheds. But these two sheds were calculated as part of the lot coverage, right? So if you had removed both of those sheds, would you still be over the 20%?
I would, a little bit.
Okay,
You want the numbers?
sure, you have them.
I have them somewhere.
Okay.
I think we would come in at 20.27,
So you would still need the relief.
yeah.
Okay.
Believe me, we tried.
Because that is the only, nope, he's non-conforming in the front.
Any other questions from the board?
No.
Mr. Chavez, thank you. We'll just turn it to public comment if anyone has any. Any questions, comments, concerns regarding this project? Okay, seeing none, back to the board. How would the board like to proceed?
I will move that we close the hearing.
Second it. Move to close by Kim and second by Ed. All those in favor? Aye. And what would be the board's pleasure?
I would move that we approve application 6518.
Okay, motion made by Kim. Is there a second? Second by Ed. Thank you, Ed. Moving on to findings.
Yeah, so 4 bedrooms remaining, 4 bedrooms. It's proposed additions 28, I think it was a 0.6 feet. Basements unfinished, crawl space to remain. Applicant's amenable to installing dry well per recommendation of his engineer. It's going to increase the utilization of the property.
Not more detrimental.
Not more detrimental.
242.16.
216. I think that there was,
Would you like to make a finding about the
242.16.
sheds and the
well,
lot
I mean,
coverage?
that the relief would be necessary to go over.
And that it meets 240.69E.
Yes, yeah. But, I mean, yeah, the height's, certainly reasonable compared to a lot that we see, and, yeah, so maybe it would be worth just noting that the sheds would still, if they were removed, they would still need relief pursuant to 240.69A.
All right. How
Oh.
about conditions, or if there's any more findings?
Conditions per plans, 4 bedrooms. Oh, dry wells.
And do we want to include,
Locations
Sari mentioned about the southwest corner?
for the addition should be southwest corner.
At least near the, at the edge, like the northwest and possibly north-south, anything to help it not go into the driveway onto Hatch Road and to the abutter. So it should be at the southwesterly portion of the addition, and the exact locations can be the discretion of the engineer, if that's okay with the board.
That's fine.
I think that's fine. Any other conditions? Okay, seeing none, motion was made by Kim and second by Ed. All those in favor?
Aye.
Aye. Congratulations.
Thank you.
Sorry for the little boy's chair, Ken. Sorry for the little boy's chair. That's what happens when you're late.
Yeah.
I don't know where the other chair went.
It must have,
We'll
water
just-
quality people took it.
We'll let the record reflect that Ken Foreman, our vice chairman, joined us. I made no mention of the chair.
Good night.
Right.
Good night, thank you.
Up next, we have application 76-18, Fenwick and others, 4, 6, and 10 Dwight Place, Falmouth.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Massachusetts General Laws, you are hereby notified that Judith Fenwick and others of Falmouth, Massachusetts filed an appeal with the Falmouth Town Clerk pursuant to General Law, Chapter 48, Sections 8 and 15, and 240-202 of the Code of Falmouth regarding lack of determination from the Building Commissioner for zoning enforcement violations on subject properties known as 4, 6, and 10 Dwight Place, Cemetery Lane, Falmouth, Massachusetts. And there were no referrals
No referrals received.
received.
I did send it to the building department. They said they had nothing of record.
So, if I may, Chairman, I just wanted to bring up, I think what's a jurisdictional issue, in my opinion, I'm sure we'll hear from the applicant, but under 40A, section, everybody's familiar, under 40A, section 7, when you seek zoning enforcement, the building inspector has 14 days. It's not mandatory, let's say, they're supposed to do it, but it's not a drop-dead deadline. And my concern, and so what happens is if the building inspector doesn't respond, Paul, I'm sure you know this here, since you're a building commissioner, you may be able to, you should probably be the one saying this, but, so if the building commissioner doesn't respond, then, you know, after, and there's some effort made to get him to respond after a long period of time, or I think an extended period of time, the case law provides, that then we could maybe possibly assume jurisdiction. I will say, I think this is pretty quick. And my concern from a jurisdictional kind of perspective is that if we assume jurisdiction where a building commissioner doesn't respond within a month or within, you know, a month and a half, we're kind of setting up for a bad precedent. So it's my only concern at the beginning. I don't know if anybody else shares that concern. It looks like the enforcement request was made at the beginning of July, and then the application came in August 23rd. So I don't know if I'm going to be able to find that we have jurisdiction to even hear this, kind of at the outset. So I just wanted to put that out. I didn't know if anybody else had any concerns, but I just wanted to raise that.
Thank you, Kim.
You're welcome. No one else has any concerns?
I'd like to hear from the applicant,
Sure.
maybe.
No, I share your
Yeah.
same concerns, Kim.
Well, let's get a consensus from the board before we ask Attorney DeWitt to go forward. If anybody has question on the jurisdiction and if it's properly before this board.
Well, I would certainly like to be heard on jurisdiction.
I'm just a minute, Ed. Let me hear from the boards for the record, please.
Yeah, for the record, I would like to hear from the applicant.
I heard from you, Jerry.
Well, no,
I'm
I just
asking
want
for
for
the
the
board.
record. And I'm talking to the chairman.
Yes, I would like to hear from the applicant. I think this is not the first time I've heard of concerns about slow response to zoning complaints.
TJ?
Okay. Anyone else on this side?
Well, it looks like some of this goes back to July 3rd, so this whole summer's been, I'm not sure exactly, it seems to me the building commissioner should be doing something, but.
Paul and Bob, anything?
I mean, I guess I'd like to hear from the applicant, but I definitely understand where Kim's coming from.
Yeah, I understand what Kim's coming to, but I would like to hear from the applicant. I have the same concern that we've seen a delay in cases now with the building commissioner on responses.
For the record, thank you.
Okay, so I think the majority of the board would like to
Yeah,
hear
that's-
from
yeah.
the applicant. And,
I have one thing. Can somebody turn on that light over Ed? Attorney DeWitt, please.
I don't know where the.
I don't want to
switch
leave you in the dark, Ed.
is. I'm always been in the dark, you know that.
Oh,
Oh, that helps.
Wrong
The
direction.
one next to it,
Up ones.
Jerry, right in
Up,
between. Just turn all of them on.
there you go.
Thank you. Thank you. All right, Ed.
Good evening. My name is Ed DeWitt. I'm a local attorney. Let me talk first on the jurisdiction issue, and then I would go into my presentation if you want me to proceed. So under the law, the building inspector has 14 days to respond. And if he doesn't respond under the law, you have 30 days to appeal. I actually thought your argument was going to be that we had waited too long to make the appeal, but I think one of the more telling issues here is this has been sitting around since July. We've made the appeal to the Zoning Board of Appeals, and the building inspector didn't come and say, I would like more time to look at this. We, in fact, went to the building commissioner at the end of the 14 days and said, what would you like to do? And he said, I would like to have 2 more weeks to decide this. And we sent a letter, you have a copy of the letter. All of the neighbors agreed to give him more time. At the end of those 2 weeks, we then went back to the building commissioner and asked him, do you want more time, or what are you going to do? And there was no response. Didn't answer messages, didn't answer phone calls or anything like that. So we're sort of in a bind. We have limbo. My only option at that point is to file an appeal with the Zoning Board of Appeals. I do not think that you can deny jurisdiction for the appeal. The appeal qualifies with Chapter 40A, all of the sections in terms of appeals. So there's not a jurisdictional question here. It's also, we're alleging illegal uses, and as you know, there's no statute of limitation on illegal uses in terms of that. So that's our position on jurisdiction in terms of what's going on. The neighbors have asked me to make a public comment concerning their relationship with the building commissioner, which is part of my general remarks, which I'd like to make to you this evening. So are there any questions from our perspective on jurisdiction?
Any questions?
If we took jurisdiction and we weren't allowed it, someone would have to appeal it. In your opinion?
If you claim that you didn't have jurisdiction, then we would have to seek further appeal, obviously, of that. Because what would be our recourse? We have a building commissioner who says, I'm not going to answer this question. We have a zoning board that's saying, oh, no, we don't have jurisdiction either.
What's the
And
answer?
and we have neighbors.
The answer to that is that you file a mandamus action pursuant to general laws.
But
That's the action.
Mandamus
That's
in a
the action.
zoning case?
Yes. That's
But
what Mark
what- and-
Borowski says in his handbook.
And-
It's a
and what-
mandamus action.
and-
You
and-
seek
And what is a
an order of the
mandamus?
court. I don't want to engage in a legal argument with you. I'm a volunteer board member. I do not think our board has jurisdiction. That's my opinion. And sir, to be honest, once we get through all of this, I am going to maintain that objection. I don't think that we have jurisdiction.
Okay,
It's my opinion.
just a mandamus action is.
You don't need to school me on what mandamus
No,
action
no,
is.
but I
sir.
think the rest
know
of
what
the,
a
I think the
mandamus
rest of the
action is.
board needs to know what a mandamus action is.
So you can,
A mandamus action is an action to do what it is your legal duty to do. And that's what we're being told to do.
seek a mandamus action, file a lawsuit. You said, you represented to this board that you had no other options but to file an appeal. That was what you said, and that is
Within
not
the
true.
zoning umbrella,
That
yes.
is not, that's not true.
Within the
I
zoning
respectfully
umbrella, sure.
disagree.
Under chapter
I respect-
48. Under
I
chapter
respectfully
48 is
disagree.
the only thing
And I
that we
also
have.
disagree with your recitation that you have 30 days to appeal a non-response. I think the case law is clear that that's not the case.
Well, I
But
would
that's
disagree
fine.
with you on that.
Case law is clear, it's not the case. So that's, I'm just saying, I don't agree with what you're saying, I don't agree with how you're representing the law. I'm familiar with this based on my personal experience, but you proceed. I mean, everybody seems to be on board with it, but I just think that there have been some misrepresentations, that's all.
My question was, what happens if we grant it? Does the other side can then
Jerry, that's
appeal it?
great. People can appeal any decision.
Well,
that we make.
I'm asking for my own clarification. We understand what the actions are if we deny it.
Well,
I'd like to know what the actions are for the other side if we accept it.
Well-
That's me before the hearing.
what I would like you to do is to actually listen to the relief that we're asking for this evening and consider whether that is reasonable under the circumstances and where we're at. And if I could proceed with my presentation, Mr. Chairman.
You may.
As I said, I'm a local attorney. I live in the neighborhood. And how I got involved in this is that different neighbors came up to me and said, we have a problem. There's a series of break-ins in the neighborhood. There's a series of dog attacks. We've got a junkyard up in the neighborhood. There's suspicious activity going on in the evening. And it all came back to this same property address on Dwight Place. And if you've looked at the property, it's a very secluded, almost idyllic property that sits up against the town cemetery and Cemetery Lane. And you have to be doing something there to be noticed. And trust me, the property was noticed. There is an indeterminate number of people, perhaps a dozen or more, living in various structures on the property. There was an absentee owner. There was an assortment of abandoned vehicles scattered across the property. You have photos in the record. Identified a number of zoning issues during the investigation, whether the lots merged in the 1940s, whether there were multiple dwelling structures on a single lot in violation of the zoning bylaw, whether it was in fact being operated as a flop house operation, an illegal boarding house, setback violations requiring special permits for structural additions, and unregistered vehicles, essentially a junkyard. I filed a request for zoning enforcement with the building commissioner. He contacted me asking for additional time to investigate and respond. Each and every neighbor involved gave their consent for additional time. The time the building inspector requested was 2 weeks, and we gave him the 2 weeks. That was his request. That wasn't our request. After that, I had no contact with the building commissioner, even though I went personally to the office and I left messages for him to say, what is going on? I waited nearly the 30 days after that extension period of time and then filed this appeal. As you know, zoning is all about history. Non-conforming uses must be legally commenced. They can be legally commenced either by predating zoning or being legal when use started and be in continuous use that is not abandoned. The history of this property is very clear. There's no ambiguity. There are Registry of Deeds records. There are newspaper articles in the Enterprise specifically outlining the use of the property. There are town records. All of the evidence in the records before you. I mean, how many properties in the town of Falmouth have a newspaper article spelling out how the property is being used, what the vision by the owners for the property was when they purchased it, and how they're using it? For lot merger, you need to examine the plans and deeds conveying the property to the Panises in the 1930s and 40s. Each deed was recorded with a plan. These plans predated enactment of the Subdivision Control Act. Prior to the Subdivision Control Act, one merged lots in abandoned ways exactly as was done here. Record a plan in the Registry of Deeds. Indeed, one of the purposes of the Subdivision Control Act was to alleviate the challenges for Registrar of Deeds in accepting these exact type of plans. And that's how we ended up with the A&R process. If you need a reference for the history, it's Smalley versus Planning Board of Harwich, 10 Mass. App 599, 1980. The 1944 deed and plan are the key instruments, and if you have the plans in front of you, you might want to look at the two plans, the 35 plan and the 40 plan. There is no reason to include meets and bounds for a previous conveyance unless you're merging lots, and that's exactly what they did in the 1944 deed. But more importantly, if you compare the two plans, in the record, it is even more obvious that the intent was to merge the two lots. Why even file a plan in the Registry of Deeds unless you intend to change boundaries or eliminate ways? The lot boundary is eliminated. It's just vanished. The way that ran down between the two lots vanished. It's gone. A portion of the way is completely eliminated. There is one lot on that plan, not even a hint of two lots. The Swartz case from the land court makes clear that the 1944, you were allowed one dwelling structure per lot in the GR district. That is how the Panises used the property until Mrs. Panis' death early in this century, and the current owner inherited the property. We know how the Panises used the property because the Enterprise did a feature article on the property and its use. It was a dwelling, a jewelry lab, and a chicken coop. You can read all about it in the Enterprise, and you have that article. It was the property conformed to zoning, a single dwelling structure and allowable accessory uses and structures. Let's talk about the flop house. Mrs. Panis, I'm sure, is turning over in her grave. Read the article and see what Panis' vision for the property was. Mr. O'Donnell, the property owner, who inherited from Mrs. Panis, told the neighbor he didn't know who was living there or how many people were living there. Mr. Hildreth, one of the people the police arrested, supposedly kept track. The police tracked at least 2 neighborhood break-ins directly back to the locus, one by tracks in the snow and the other by a tracker dog. There was an unusual amount of police activity at the property, and we have submitted police logs in the record. One of the principal purposes of zoning is public safety. The nature of the property, its isolation, multiple buildings, makes it difficult to count exactly how many people are or were living there, but the neighbors are here and can tell you what they saw. They can tell you about suspicious activity in the middle of the night. They can tell you about their homes being broken into. They can tell you about suspected drug activity, and they can tell you about vicious dog attacks. As I reported to the zoning administrator, since this appeal was filed to the board, there has been some improvement at the property. There's a letter in the record describing those improvements. But what do the neighbors really want, and what are they asking this board to do? They don't want anything torn down. There's no question the building permit was erroneously issued in 2008. But the neighbors believe that that can be cured, and the project should have had a special permit. What they want is a permanent end to the flop house, essentially a finding that there was an illegal boarding house on the property. They want the board to make a finding that it's a single lot. The lots were affirmatively merged in 1944. And they want the current owner, Mr. O'Donnell, to file and obtain a special permit from this board that conforms to zoning. I've outlined what the neighbors believe conforms to zoning, but it's up to the property owner to develop a permittable plan. There should be firm timeline for that special permit application. Otherwise, he should lose his occupancy permit. They want to state publicly their disappointment in the building commissioner. They feel that if he had taken appropriate action, either at the time of the building permit application, and that was a prior building commissioner, or the request for enforcement action, the neighborhood would have been far better and safer. In the record is a zoning history, a property history, recorded plans, newspaper articles, and other supporting evidence. I'm happy to answer questions that you might have. I think this is a reasonable ask by the people who have gotten no action from the building department and the building commissioner and the zoning enforcement system that is set up by general laws. And I think we're well within our rights to request this relief. Thank you.
Thank you, Attorney DeWitt. We'll start with Jerry. Do you have any questions?
If relief is granted or we agree with the argument, what is the next step? They apply for special permit. A lot of the things you listed, I don't think are jurisdiction, but.
No, I
mean,
think.
what happens if we agree with you?
Well, one of the issues of that property is the frontage on Cemetery Lane, and I think that's really important in terms of setbacks of different structures and whatever. And there was a additional structure added that should have been here for a special permit back in 2008 that didn't happen. We're asking that that happen now and that he develop a plan that complies with zoning. And that's his plan. He has the, and there's a lot of latitude within the GR district in terms of what he can ask for. And I don't think it's the position of the neighbors tonight to sort of say, this is the only thing that we're going to accept. They want to see a public process that conforms to the zoning bylaw. I think we've outlined numerous violations that were occurring that are specifically zoning violations.
Are they, well, another question. These are then all within the 10-year. I vaguely remember something, if something's
The
done
10 years
illegal
is
for
about
10 years.
tearing things down. We don't want anything torn down at this point.
Even non-compliance with
The,
a zoning?
the use violations.
Okay,
which-
use violations,
which
thank you.
Have no statute of limitations.
Okay, thank you.
The structural violations have a statute of limitations. I think we arguably have met the burden under that statute of limitation by filing the appeal before the 10-year period had run out. But we don't want anything torn down. We're not looking to be vindictive here. We're looking for compliance with zoning. That's what we want. We think that's reasonable. That's not an unreasonable or lack of jurisdiction request.
Ken, any questions?
So review again how the use is non-conforming.
The multiple dwellings or multiple structures being used as dwellings is non-conforming.
Or more than one,
More than one dwelling
Dwelling on a lot.
structure per lot.
and you argue that because these were supposed to be merged lots.
It is a merged lot. It's not,
Okay.
not supposed to be. But even if it's not, there's still a problem because there's multiple structures that are sort of being used
Were
as.
those structures on the lots at the time they were merged?
Three of the structures were on the lot. What became the Panis's dwelling, the Panis's jewelry laboratory, as it was called in the chicken coop.
Any other questions, Ken?
I think for now, that's it.
Kim, any questions?
Yeah, so I have a question about the 2008 building permit. I didn't see it in our files, but maybe I just missed it. Was it submitted, the 2008 building permit?
The permit itself?
Yes.
No, the record of the property was there with the 2008 building permit, but the permit itself is not
Okay,
there.
so what did that permit authorize? What was that building permit for?
It authorized a large addition of 2 bedrooms on what was an addition to the laboratory, and a garage, 2-car garage.
So prior to that, that structure wasn't used as a dwelling?
That's correct.
Okay.
And that's part of the issue in terms of why we think a special permit would have been required in 2008.
Okay. And does that permit, I think it would be helpful if we could have that submitted. Does that permit identify a use on its face? What that building was going to be used for?
I believe it was a single-family residence.
Okay. So I think it would be helpful to have that. That's all I have for right now. I'm sure I'll have others.
I'll check what I have this evening, but it may have already been submitted.
Could we please check the file, because
I did look
I
at
don't know
that.
if it's a conversation Ed and I had, or,
Maybe I missed it. I'll look, well,
but I don't
others are asking.
think it was for a single-family dwelling. I think it just said the addition of bedrooms, electrical.
Yeah,
I'm
there-
not sure.
There is something in the record about what was included but the actual building permit is not in the record. There is,
I don't think it has a CO yet.
Kim, if you're still looking, we'll.
Yeah,
we
move
can go
on.
to Ed.
Move
Ed,
on.
any questions?
Does it look like we'll ever find the building permit for that 2008?
I'm sorry?
Are we ever gonna find that building permit for 2008?
It's, the building permit's in the building, department,
Oh, it is.
yes. It was granted. There is something in the record about the permit. I'll try and dig it out.
I thought we had it, I'm sorry. We
I didn't see
requested
it, so-
information from the building department, but we did research Municity, so if I missed it, I apologize as
Melissa,
well.
I might be looking in the wrong place. It's a possibility, too.
Is there some reason the building inspector isn't here?
I can't answer that question, Ed. He got notice of it, they get a referral, they get the agenda. everything's posted, and I recently spoke to their office because I hadn't received anything.
And I just have a question on the merger issue. Is your argument that there are now 2 dwellings on one lot?
My argument is that there are multiple dwellings.
Okay.
On
But before,
one lot.
but before this, but were there, so back in its history, was it one, were they, so the issue at hand is your point is that there is one lot with 2 dwellings on it, and that.
Maybe 3.
Okay.
There could be 3.
But was a plan filed?
No.
Okay, so my point, I guess, is, on the original plan, was it 3 separate?
So original plan, there's, if you really go back, there were 3 lots here.
Yeah.
That's why
With
there's
it-
3
Okay, okay, when you really go back, so there were 3 lots. Did each lot contain a dwelling unit?
There's the 3
A
lots.
cottage?
Okay, so
Yes.
way back.
Okay,
These are the 3 lots.
Before,
This is it.
before the
These 2
Panises
lots
bought
have
it,
houses.
so,
this was part of the Swift estate.
no, I get it. I guess my
Okay,
point is.
So these are very small cottages, places. They were for seasonal help
Sure,
that go way back.
but each cottage was on its own lot?
Oh, yes.
Okay,
Okay, so until 1944.
yeah,
And then you merge the lots, and they suspended using the one cottage as a dwelling.
but I guess my point is.
So that was abandoned. That dwelling was abandoned.
Well, I guess my point is vacant land merges. Lots that are already developed with real estate on them never merge. If you bought a lot, just my point, if you bought a lot in Mara Vista with a small cottage on it, and you bought the lot next to you, and it had a small cottage on it, and you took title to them in your own name, they never merge.
You could file an A&R plan and merge those lots, and that's essentially what the Panises did.
Is there an A&R plan, though, on file?
This predates A&R. So what they did was an A&R plan. It is, in fact, an A&R plan before an A&R. They removed
The rubber meets the
lot
road
line.
at the Registry of Deeds. So if you go to the Registry of Deeds, what do you see?
In terms
there a-
of the plan, you see the 1944 plan
Yeah.
with
It's in that thing
the,
that you
and the
Right.
deed, reading the deeds together. One set of meets and bounds
Yeah.
for the whole large lot. You
Mm-hmm.
see the plan with the way removed that ran down between the 2 lots.
Yeah, so, but
And the lot line. That's the key. The lot line is removed.
I mean, I'm not buying that.
Why would you file a plan with your deed in
But
1944?
you can file anything.
But you have to go to the expense. It's
Yeah,
a-
no, I realize that, but
But
two
unless you were,
single-family homes, regardless of whether they filed an A&R plan, in my opinion, wouldn't necessarily grant those.
but that's what the Panises wanted to do, because
Yeah, but-
if you read the newspaper article, this was their vision for the
Yeah,
property.
no, I understand, but I'm not buying the merger issue at all.
Well, it was merged.
I'd have to look into that a little more, but I'm not seeing that at all.
That's how the plan in the Registry of Deeds is, and if you went to buy that property,
Mm-hmm.
you would be buying one lot. That's what you would be buying. That's how it's described in the
But
Registry
that,
of
so that would
Deeds.
be a zoning violation that would have evaporated after 10 years. It happens all the time. People convey parcels of land from they already have.
There wa- See, but that's the whole point. There was no zoning violation. The only,
Yeah, so the issue of merger, in my mind, is non-existent. It's nothing we can take enforcement action against.
but you're making the
It happened in the 40s, it's
determination
over.
that there's one lot here for zoning purposes.
Yeah, but you're arguing that the merger issue makes it a zoning violation, correct?
No.
Okay.
Okay. You have to look at what happened in history. When was the
Yeah.
When was the property conforming? When was it non-conforming? Okay, the Panises owned the property from 44, the whole property, from 44 until she died in 2001. That entire period, the property is conforming to zoning except for a setback on Cemetery Lane.
Okay.
That's the only zoning violation.
All right, so this
And
issue of
that's
merger.
pre-existing. That's a
Yeah.
pre-existing, non-conforming setback. So then you get a new owner who comes in, and he creates a whole host of problems because of having multiple dwellings on a single lot, of the other issues associated. But that is the one that we're really talking about.
Yeah,
right
no,
now.
I guess maybe I'm just a little confused. The violation of the town code, more than one dwelling on the single lot, but, I mean, that was done in 44.
No, because in 44, there was
That's the A and
one-
R plan they filed creating one lot, though, no?
Right, but it didn't create a zoning violation.
Well, it
Because
doesn't
they were-
create one
There was
now.
only one dwelling on the
Yeah,
lot.
Yeah, but that's 70 years ago. There's no zoning violation related to that now. I don't see it.
No, he's saying that the zoning
He's saying
violation
the use
occurred when the
changed.
new person, when the person bought it and created multiple family dwellings.
Before that, it was. one.
Previous to that, it was in compliance with one house, something that she used
We're
as a
gonna need more
jewelry
time on this.
thing, so.
Yeah.
Okay, so the Panises got exactly what they wanted. They wanted one lot. That was their wish. They had a vision for the property, to have their gardens, their jewelry laboratory, their dwelling, and a chicken coop. And they had it all on one lot, and they did that. So let's take your Mara Vista example again. Okay, and let's say that someone went into Mara Vista and they bought the two lots, and they converted one of the lots, one of the structures on the two lots into an accessory structure. Completely legal. They have one large lot, and then a future owner comes in and says, no, I want to have two structures on that lot. That would be illegal. And if anything, you would need some zoning relief in order to do that because of the one structure, one lot rule. So you have to look at how the property was used and how that use measures up to the zoning bylaw.
Yeah, I'm gonna need more time on this. I'm not sure I totally agree with you, but
So just a question on the structure. So on that, on the back lot section, what looks like a colonial, that was their main dwelling?
No, that's the new addition.
That's the new addition. And then the long single story, was that the
That was
laboratory?
on the closest to Cemetery Lane.
It shows all the doors across the front.
On the other side. That was the original dwelling.
That was the original dwelling. And then the smaller cottage, is that what you're referring to as the chicken coop?
The chicken coop's a back building, sort of closer to the cemetery. And then there's a little bit of the original laboratory that's still off of the new addition. But I'm not even sure that those are connected. I don't know if there's an internal connection between those two or not. They're attached on the exterior.
And do they have access to Cemetery Lane?
They have frontage on Cemetery Lane.
That's all I have.
Cemetery Lane is
Back
a
to what
public
the
way.
Thing's about.
was the building permit issued prior to October 18th, 2008?
It was issued, I think, in August of 2008.
Yeah, doesn't 48 say you've got to file an appeal in the court? In court, right?
No.
Not with the Board of Appeals? Yeah? Okay, okay, all right.
Attorney DeWitt, so just going over the timeline of this entire enforcement action. On July 3rd, 2018, you made the initial request for enforcement with the building commission?
I believe that's correct. If you want me to pull my records out, I can do that.
I'd appreciate it if you could. I'm trying to nail down the dates here.
What you have in front of you?
July 3rd was the original.
And then you have correspondence to the building commissioner dated August 6, 2018, in which you both mutually agreed upon an August 10th deadline.
Yes.
And then you filed the appeal with this board's office on August 23rd.
August 23rd.
Those are all the questions I have for right now. Kim, do you
Yeah,
have
so I just
follow-up
had,
questions?
so I just want to, I think maybe we're not really understanding what exactly is being appealed. So there were 3 structures on the property. We're not concerned about the structures, putting aside for the time being the 2008 building permit. So 3 structures, one was used as a dwelling, 2 other were used kind of accessory to that, let's say.
That's correct.
Okay, so 2003 comes, property is, I don't know if it was deeded, or I think it said, I saw a reference to a will. New owner comes in,
Yes.
starts using 2 of those 3 structures as dwellings at that time?
The neighbors might have more information. I'm not exactly sure when and how the property, personally, I didn't pay any attention to the property until earlier this year, when people started coming to me and say, we've got a real problem in the neighborhood, can you help?
Okay, so, all right, I'm just trying to get, I kind of goes to.
I do know that the current owner was living this whole period of time from 1989 until this summer in North Falmouth.
Okay, so, but not
And
on this property.
he owned
is
the
what you're
property
saying.
in North Falmouth.
Okay, so, so right now, we're saying, we're challenging the use of the property for 3 dwellings. Is that true?
I think there is likely 3 dwellings. Without going inside of the buildings,
I get, yeah,
I can't tell you whether there are in fact 3 dwellings. We know of at least 3 different entities who reported renting different areas of different structures from the owner.
okay.
And, you know, that's all hearsay without going in and actually seeing what's there. I can't tell you how many dwellings are there. I can tell you how many structures there are on the outside.
Right.
I can't tell you what's on the inside.
I mean, I'm just trying to get a sense of what I mean, I get that there's a lot going on. There's appearance of a lot of different stuff. You have multiple, but I just really want to know, like, concretely, so it's there's a lot of people living on the property. We think that there's multiple dwellings.
There's
We're
less
not sure.
people living on the property now.
Today than-
Yes.
Yes,
A-
okay.
And trust me, there were a lot of people living there, and there's noticeably less people there now.
Okay, and then you make reference to a boarding house, a flop house. Is that still a concern, that these are boarding houses?
We don't know.
Okay,
And I can't tell you today how many people are living on the property and where they're living and how those things, and that's one of the reasons to file for zoning enforcement, is because the building commissioner can even get an administrative search warrant to go in and figure that out. We had asked for the building commissioner to talk to the police, because the police had executed a number of search warrants on the property, and that they would have firsthand knowledge of how the property interior laid out. I don't know.
okay. The 2008, I'm gonna go back, because I think the 2008 building permit is important for a component of this. Large addition, 2 bedrooms, so we know that's a residential use. We don't know if that's a multifamily use or single. You said you think it may say single family, it may not.
I'll look again, but it was clearly 2 bedrooms, residential, and
Okay. And we know that was issued in 2008, and you're seeking revocation of that permit, right? I mean,
no.
that-
What we really, we originally sought,
was-
what we
yeah.
originally sought was revocation of that building permit.
Mm-hmm.
And that was done primarily to get attention of both the owner and the building commissioner. But really, what the neighbors want is for the property to be brought into compliance, and they believe that requires a special permit to bring that into compliance, including the new addition. And that's why they're saying they don't want anything necessarily torn down. But
Okay, but the building undertaken pursuant to that 2008 building permit, and any use undertaken pursuant to that building permit is at this point beyond challenge.
the use is not beyond
Yes,
challenge.
it does, because if there's a use expressed on the face of the building permit, that's why it's so important. If the use is expressed on the face of the building permit, it's a 6-year statute of limitations.
Not any
If
illegal
it's
use.
not permitted,
Okay,
then it doesn't matter if it's an
So-
illegal use, if it's on the
right.
face of a permit, it's 6 years.
but then that means that the other dwelling has to be abandoned.
No,
No.
Because it's a different structure. You're looking at different structures.
Kim, I agree with you.
yeah, no, I mean, I'm just trying to wrap my head around exactly
Me
what
too.
you're seeking. So you're saying we're not revoking the 2008 building permit, but you want either a variance or us to order either a variance or a special permit?
An application,
An right, understood.
yes.
Okay. That's what you're looking for,
That's
to have multiple dwellings on the property.
or not. I think it would be difficult for you to grant, I don't think you have any authority to grant a use variance,
We don't.
first of all. And then to grant a special permit for something that violates zoning, I think would be difficult. So I think that what the neighbors are saying is if he wants to build his one dwelling on the lot around the 2008 structure, that's fine. But he's got to come up with a plan for the rest of the property so that it can't be used as a flop house again, so that he starts renting out spots in all these other structures on the property to people who are there on short-term basis and not for good intention.
Okay. This house, the one house, the 2008 house, let's say it's permitted as a single-family residence. Is there any other permit in place for those other structures? And do we know for sure those structures are being used as residences, I guess is?
Yes,
So the 2 other structures are definitely being used for residences?
yes,
In addition to this one?
yes.
Okay, because 5 minutes ago you said that there's 3 structures, you don't know how they're being used. So
I know there's people
trying
who
to make
have,
sense of this. you
okay, so today is what I'm saying. Today, I can't tell you who's living in what houses. Within the course of this appeal period, people were living in all of those structures at some point. And I think that's where that confusion is coming from. I don't know who's where today, but over the course of this appeal to the building commissioner, yes, they were living in all of the structures there.
All right, that was all I had for the time being.
Thank you, Kim. Any other questions from the board at this time?
This may be in the file, I have to be honest, I haven't had a chance to look at the file. How large is the lot?
Off the top of my head, I don't know. I'd have to go start looking at the plans and see if it's there, or it's on the assessor's record, one or the other.
Well, if you have your calculator, Ken, you can figure it
240,
out, because it is there with dimensions.
Right
Does
there.
it-
But I'll pull the, probably says it on our,
Where did my glasses?
I don't see the square footage on the
No,
lot.
it's not. He'd have to calculate.
Yeah,
oh yeah, it's over 1 acre is what it says on our kind of
That's about right. When
case
you go,
intake
when you
sheet.
go look at it, it's about an acre.
Right, but it's not large enough to subdivide. I guess that was where I was going.
No, they can't re-subdivide according to zoning.
Any other questions from the board?
No.
Sari, do you have any questions?
So you don't know if there's actual kitchens in the other 2 units. You know that bedrooms were added, and, you know, people are living in all three. Excuse
It's
me.
my understanding that there are cooking facilities in at least 2 and probably 3.
Okay. And have you contacted the Board of Health about possible, any issues with septic, anything like that? Any overflow issues or anything? Were they able to?
I had a conversation with the health agent, and you have to understand that the original we're talking about 700-foot structures, which
Right.
were the original, those are really small, and because of the size and whatever, there wasn't, they didn't see a reason for a problem, and because of the 2008 building permit, I think it sort of escaped.
Okay, thank you.
But you have no direct knowledge of whether or not there are kitchens in those units, right? It's hearsay? Like, you have direct knowledge of what's going
Well,
on?
Okay, so I know because I was in Mrs. Panis's dwelling that there were, when Mrs. Panis was alive, there was a kitchen in that. That's the one closest to Cemetery Lane. It's my understanding from that there is cooking facilities in the new addition, and it's my understanding from a prior renter that there were cooking facilities in the other small building adjacent to the new building. And the neighbors may know more than I do. There's a number of neighbors here who have probably better knowledge than I have, because
Has
they
anyone-
live it.
Has anyone reached out to the property owner, the building, to your knowledge,
I've-
the building
I've-
inspector, anyone, and call this person and say, hey, what's going on?
I've spoken with the property owner and had some discussions, and I think he is of the opinion that he's doing everything legally. He has some regrets about what was happening with people who he didn't know were living on the property, and feels that everything is okay.
So I have a question. How many people does he lease to or rent to?
At this point, I don't know. If you look at the town,
But I mean, he didn't volunteer that information to you
No,
at all?
no.
So we don't know how
and
many
he
leases?
is apparently living there now himself
Okay.
on the property. He has moved to the property, is my understanding.
All right, thank you.
A quick question. Who in town has the authority to say, we want to inspect these other buildings to see if they have kitchen, bathroom facilities, if they're habitable?
I think that's probably the best question for town council, and I think there are a number of avenues that you can use, including, if necessary, an administrative search warrant, if you don't get permission. And there are a number of town agencies and bodies that frequently go and ask for owners to cooperate with those types of inspections, but there are legal remedies if you need to get onto the property. I would, I don't want to speak for the owner, but my guess is that he would probably cooperate if that had happened. But that's one of the other frustrations that the neighbors have with the building commissioner, because that didn't even happen, since July. And there is frustration in this room with that process.
And I had a follow-up. Although we're not into discussion, it appears that we may need more information, at least from my opinion, and I'm not even a voting member, but a continuation might be in order to try to.
It's a little premature, the board
we
really
can
I
needs
know,
to
but-
discuss first.
I want to have a discussion, too.
Yeah.
Were you gonna say anything? Were you
No,
looking
no,
for
no, I
something?
just,
Oh, I didn't know if you were
whether
looking for
he
something
thought
in
a
particular.
continuation would help matters. The applicant can always ask for continuation without a further discussion.
I don't believe the applicant is here tonight.
Well,
I mean, the owner is here tonight. I'm the applicant. I represent the
Hello, Ed.
applicant.
continuation of your appeal, or whatever you want to call it.
But I think that also says something as well, the fact that the property owner's not here tonight.
All right. I didn't get an answer, so.
All right. now might be an appropriate time to turn it to public comment. Would anyone wish to speak regarding this?
2 minutes.
And we're going to limit this to 10 minutes, and it's usually two minutes per comment. So, ma'am?
Hello, I'm Judy Fenwick. I guess I'm the lead author on this. I am a direct abutter, and I have been in the Mrs. Panis's cottage, which was the original dwelling on the property, which fronts on Cemetery Lane, and there is a kitchen facility. And it has been leased to a family of 3, sometimes 4 people, and it's a 1-bedroom cottage. Probably, let's see, the young man I met there, he was in 7th grade, and he's now 30. So what's that been, about 20 years or 15 years? So there's been a family of 3, sometimes 4 people in the 1-bedroom cottage. The jewelry lab was not a dwelling at the time I moved to the property. It was still Mrs. Panis's lab. I don't know if there was a stove in there, but I doubt that there was. She had to have some means to melt silver, and I don't think a normal stove would provide that. That dwelling got turned into a dwelling, declared a dwelling in order to get the addition put on. And Ed, what's the date of the addition? 2008?
2008.
Okay. I have not been inside of that, but I know that there's a kitchen in there because there was constantly a smoke alarm going off from cooking. I'm surprised to hear that there's only 2 bedrooms there. I did talk with Mike O'Donnell in March of 2018, when we'd been having a lot of what I considered personal and public safety issues, and asked him how many people were renting. And he said, 1 that I know of, but he goes to AA and NA meetings, and he's trying to help some people out. So he didn't know how many people were living in the addition at that time. He literally had 1 person who was paying him some rent. And it wasn't a lease situation, it wasn't what I guess you call at will, so a month-to-month arrangement. So that's what I know about who's been occupying.
Thank you, Ms. Fenwick.
Can I ask a question? So you talked about the cottage, talked about the jewelry lab. Is there any other structure being used for residence?
Well, the chicken coop that I think Mr. Dugan was referring to is the low building with a lot of doors on it.
Yeah.
That's closest to Cemetery Lane. There were lights in there one summer as if somebody was living in there. And I was surprised, I didn't even think there was electricity.
Okay. And how long ago was that?
Probably 4 or 5 summers ago.
Okay, thank you.
Anyone else?
I do have the building department parcel history.
If you don't mind coming up to the microphone, that way everyone at home can hear you.
This is in the record. I'm just not exactly.
I'll click it in. Thank you. So is there a building?
Any other public comment? Okay, seeing none. How would the board like to proceed?
How about I'd like to make a motion to close the public hearing.
Well, hold on.
Yeah,
Oh, is that too early?
yes.
I think so.
Yeah.
Oh, all right, well, board discussion.
Okay, so why not? I'll jump in. So obviously, I still stand behind my understanding that we do not have jurisdiction to hear this. I do not think that we have,
So,
I think that there's an extended period.
You have to explain
Yes.
that to me, because I don't understand, I mean, under what circumstance can a citizen appeal a decision they don't like from the building?
Well, here there was a non-decision. So there wasn't a decision, and that's the problem, that there wasn't a decision. And so if.
So how can they appeal for enforcement?
From
then?
so in my opinion, they could institute an action and bring a mandamus action. With that said, our board has previously determined that we had jurisdiction, waived the decision requirement, we basically assume jurisdiction. But that, and since I've been on the board, that's been after an extended, prolonged period, months and months, where they're not getting any response from the building commissioner. There's a decision, this Elio versus Zoning Board of Appeal, 55 Mass Appeals Court 424, 2002, where it talks about the lack of decision and how the board didn't have jurisdiction to sit and hear a zoning enforcement appeal because there wasn't an underlying decision. So, I mean, is there a point where it's, but to me, 14 days after 14 days.
What was that an appeal of, do you recall?
I didn't read all of the cases. Let's see. The
I mean,
specific issue, that was a permit authorizing certain renovations to a building. So I think, in my opinion, I think it's even more critical when buildings being, actively undertaken.
Well, for example, I mean, say you're a homeowner and all of a sudden your neighbor starts to operate a business and they haven't gotten any of
Yeah.
the appropriate permits.
Yeah.
And they go to the building commissioner and they say, we would like,
Yeah.
enforcement. Are you telling me that there's no possibility they can, without going to court, that they can just come to the Board of
That's
Appeals
what I'm
and ask
telling
for
you.
enforcement?
That's what the law says. That's what I'm telling you. And I don't want to read this whole thing, but it talks about the comprehensive zoning scheme. This is an appeals court decision. Let me see. Section 7 sets up a simple administrative procedure whereby a person seeking enforcement of a local zoning ordinance or bylaw against any other person allegedly violating the ordinance can make a request in writing for such enforcement to the building commissioner, I'm paraphrasing here, charged with enforcement, and ordinarily will receive a written response to such request with a statement of reasons for their response within 14 days. Okay, ordinarily.
Right.
Sections 8 and 15 further provide that if the enforcement request is denied, any person aggrieved may appeal. We think that it would interfere with the effectiveness of this procedure and encourage precisely the type of litigation which the procedure was designed to replace, right? It's an administrative procedure. If we were to ignore the written decision requirement, and that was even under the circumstances presented there.
So I guess this is a point of law that we're debating, and why can't we, and, obviously the applicant's attorney feels one way, and I just think we ought to ask for, this goes to Paul's question about whether we should close the hearing, I think we should get an opinion from town council.
Yes, I think that makes sense.
Because this is a very significant, if what you're saying is true, then that basically means nobody in the town of Falmouth can appeal directly to the Board of Appeals for anything that they consider to be a violation.
They can't appeal right to the Board of Appeals today. That's not what the law provides.
I understand, but, when I read 24202, it doesn't sound that way to me.
This is how, this is.
I understand.
Yes. And the
But-
other,
But there might be 3 other cases that say something different.
Right.
I don't know.
Wouldn't it be good, best to have?
I don't know.
I
So I would
do agree
like,
with Frank.
And also let,
Yes. There's can I make a couple other points?
Sure,
Because I
of
was gonna
course.
go through, I wanted to hit on
and you
some
will
points.
anyway.
I will. You only get me for a few weeks longer, Ken, so let me,
And
so,
I always enjoy that.
yeah, so the other point was, I think that there was a comment made, the 30-day appeal period. So that was a reference to sections 8 and 15. If there's no decision, the 30-day appeal period doesn't start. So it's not as if you make,
Yeah,
you
that's-
request enforcement in writing, and then the 30 days runs from that date that you request enforcement. That's not the law. The law is it's 30 days from the date the decision
I
is
agree, that's
made.
problematic there.
So
However,
that starts the clock.
there is the 6 and the 10-year issue.
Right, so let's jump into that. That's where I was going next. So I think, so even if, so I'm not going to change my mind about the jurisdiction. We can get town council's opinion. I think that's probably prudent to do. That being said, I think the building permit, so the 2008 building permit is kind of, is out of the game at this point because
Definitely.
the use and structure authorized by the building
Yes.
permit is subject to a 6-year statute of limitation. That cannot be challenged, the building
Absolutely
permit.
right.
That being said, I mean, if there's some other illegal use of some other house being used that makes it a multiple dwelling, then we can look at that
That's right.
use if we want to reach the merits. The 10-year statute of limitations is for a structure not authorized by building
Right.
permit. And I agree with you, Paul, what you said earlier, that a notice of violation has to be recorded within 10 years, and that
At the
that
Registry
requires
of
suit.
Deeds.
At the Registry of Deeds from the time, so that would have to be
This-
10 years from the commencement of the illegal structure, right? So, and it wouldn't just be filing with us, it would have to be
That's right. This-
notice of suit, so it would have to almost be a step further. So I
Absolutely.
think if there is a structure illegally constructed there,
It's over.
the 10 years,
Yeah.
I think, were missed too, but it doesn't sound like that's the case. And then use, I agree, so if there's an illegal use on the property, then there's an illegal use, and we can look at it, if it's not authorized by permit, and that's kind of the key distinction, so I think it would be helpful to get the 2008 building permit. I know we just received the parcel history, I would like to see the permits themselves, because I think it's important what it says. I think the decision, or an opinion from town council would make sense. And then I think we could, look at the merits, and I think there's a lot of facts here that we should kind of get our heads around.
Yeah, and
So
I
that's
mean,
my
and I think this kind of turned into like a circus, like just to underpin your point, too quick, absolutely. I mean, I can understand the frustrations of the neighbors, but like, zoning takes an eternity to take care of. You need cooperation from property owners, from boards, committees, the building inspector, the neighbors. I mean, it's unbelievable how long it takes to remedy a zoning violation. They go on for years. Rod misses a 2-week deadline, and then, you go back 2 weeks later, he hasn't answered you. Now this is before the Board of Appeals. We don't know anything about this property. I mean, it's way too quick. I mean, I'm sorry, whatever happened at the building department, I have no idea, but I will say, if my board did this to me, I'd be shocked. They wouldn't even, they'd be calling me saying, what do you want to do here? Or, have you answered these people? Or, I mean, now this is before, none of us know anything about it. It was way too quick. That's my opinion.
Well, I have some sympathy for, the abutters of the world who find something's going on in their neighborhood and they want to know, that they don't like, and what do we do?
Yeah, it popped it here though, and we know nothing about it.
And so, they did go through a couple of steps with the building commissioner, giving him some additional time and so forth. But it all goes really to the question that Kim raises of whether we have jurisdiction to address this, or do you have to go through the court system? It's as simple as that.
And that
I
will be
think
the
Kim's
question.
right on that. I think Kim's right.
Yeah, well, but I'm just saying,
Yeah.
I'd like to get, the opinion of Frank.
So that's a question to Frank.
This is a complete circus at the moment, I'm sorry. I mean, I know we're all trying to get our hands around it, but
The other thing I think would be
way
helpful.
too quick.
Would be helpful in terms of having more, and I don't want you to think I'm not empathetic to the neighbors, Ken, that's what you said.
Of course I don't think that.
I am, I just am also kind of a stickler for the law. But I think, it would also be helpful to understand exactly what they're looking for, because I mean, in the request to the building inspector, whose shoes we're now standing in, they requested that this 2008 building permit be struck. Now, we're being told that's not what they're looking for. So it would really be helpful to really understand exactly what relief they're requesting in writing, if it could be kind of clearly laid out. And there's this
I think
Lodgers issue.
there's a number of ways,
and-
if they did come before us for a building, for a special permit, there might be a number of ways it could be addressed, who knows?
But there weren't, from what we've been told, there weren't multiple dwellings on the property in 1959. So,
Well,
from
there
what we've
were
been told.
Not dwellings, correct.
There
They're
were
not dwellings,
structures.
which leads to my question.
But they could be
You
accessory
and Paul
apartments.
keep saying the 6-year thing, it protects the structure just like the 10-year does, and the use, if the use was legal. But if the use is not legal, it doesn't protect it.
Yes, it
I
does.
disagree.
Yes, it does.
If it
No, it
says
doesn't.
Yes,
it,
it
if it
does.
says it on the building permit,
Yeah.
it does.
Yep.
If it's
If
on
it's
the building
against
permit.
zoning
Yep.
violations?
Yes.
Yes.
I don't
If
see
it's
how that-
on, if it's a use commenced pursuant to the building permit,
How many times have
Yes.
we said a building permit does not make a use legal?
It does, yeah, after 6 years.
after 6
If I
years.
issue a building permit for a gas station in a zone where it's not permitted,
No, it's statutory, that's
Yeah,
statutory, that's
absolutely.
40A, Section 7.
If
How
I,
does the
I
building
understand
permit,
that, and I
how does the
understand the
building
6 year.
permit indicate the use?
Because sometimes
It's
it says
listed.
use, a single-family dwelling.
Well, do we have that? Does it say that?
That's why we
Yeah.
need the building
We need the
permit.
building permit for that.
And what he handed in, does that say anything?
It's, not, I mean, it says what was
History of
done,
buildings.
so first floor, where there was stuff, you know, undertaken, it doesn't really say the use, like it would on the building permit.
yeah, an illegal use can be permitted in error, and after 6 years, it's
It's no
absolutely.
longer, it doesn't make, yeah, it's
Okay.
just no longer subject to challenge.
So, based on the time, you want me to ask town council for the opinion on jurisdiction?
Yes.
Yes, please.
Yeah.
Are you asking Attorney DeWitt for any case law?
I'd like
He
him to
cited a
review
couple
some.
of things.
The case law that he
Both
cited,
sides.
I'd appreciate copies of that.
And maybe he knows the case law that Kimberly cited, too.
2008 building permit,
Yeah.
we already said
Right.
we needed that.
He's listened, so he knows what he
Right,
should,
he knows.
can come back with, yeah.
I'm just asking for the record, please.
Yeah, you know, there isn't, there's some drawings of structures, but I don't see like a plot plan. Is there a plot plan?
Well, I don't think it's, I think based on the appeal, I don't think it's the burden of the appellants
I agree.
to create a plot plan to show the board. I think that's what the site visit is for. I can do GIS maps for you,
Something,
but I don't think it's the burden of the appellant to
I would
have
agree.
a plot plan created.
Do we also ask Frank how we get entrance into these?
You cannot get entrance without permission.
Well, I
The
mean.
only way you
Frank-
can is through
Well, I just
judgments or-
responding to it, Ed said that we should ask legal counsel as to how we can do it.
We know how we can.
You request admittance, if it's denied, you go to court.
So that would be the building commission, wouldn't be us.
Yeah, I
would
mean,
it?
he can request
commissioner, Board of
admittance,
Health
if they
does.
let him in, fine, if they don't, court. But I'd
So,
like it clarified too, Kim, like, what are they, what, now, based on this hearing and what we've discussed, let's whittle this thing down. What are they specifically asking from this board?
Right.
that's what we have in the record that she asked for,
All right.
plain and simple. Okay, is there a date that you are looking?
November 1st,
Don't tell me November 1st.
November 1st.
We have executive session, we have another appeal.
November 1st.
How am I gonna get those decisions done?
Let's see, what time? November 1st, right?
Can we meet earlier?
Yeah, so what
6.
time is this supposed to
We
be
have
And
an
done?
could Mr.
executive
DeWitt make
session
it?
at 6.
Can Mr. DeWitt make it?
You have an executive session at 6.
Okay.
And you have,
I meant November
you
1st.
just continued another
Yeah.
hearing to November 1st. So now you have two, executive session, a continuance of an appeal, a continuance of a special permit, and 4 more hearings.
Can we do November 1st, please?
I'm still asking, can Mr. DeWitt make it?
We're still discussing 1 second.
I know, but when we set a date, we asked
Okay,
both parties.
all right. Attorney
I'm
DeWitt,
speaking
can you
to the
make
chairman.
November 1st?
I can make November 1st.
Will you be able to have everything handed in that we've requested
Yes,
a week in advance?
right.
So the board can review it this time.
What time is the continuation for 6118? I know that we have executive session at 6.
6118 is at 6:30.
6:30.
Okay, so do you want,
Executive session's at 6. It's gonna take about a half hour.
is it? Well, I will move that we continue this hearing, application 7618, to November 1st, 2018, here in Town Hall at 6:30.
Second.
Okay, motion was made by Kim, second by Paul. All those in favor?
Aye.
Aye.
Sorry.
That's okay. Somebody's gonna have to finish it if I can't.
Okay.
6:30. We take a 5-minute break, please?
Sure, we'll take a 5-minute recess.
Thank you.
All right, and we are back from our break. Up next, we have application 78-18, 39 Pine Falmouth LLC, 39 Pine Street in North Falmouth.
So we received correspondence from Attorney,
Excuse me, you have to read the notice into the
oh,
record.
we're opening
first.
it too?
We have to, yeah.
Oh, I see, sorry.
It was scheduled for tonight.
Okay,
so we'll
being
open
all
it.
persons deemed affected by the Board of Appeals under Section 11, that's right, sorry, of Chapter 48 of the Massachusetts General Laws, you are hereby notified that 39 Pine Falmouth LLC of Southborough, Massachusetts, applied to the Zoning Board of Appeals for a special permit pursuant to Section 240-23I-5B of the Code of Falmouth to construct a detached accessory apartment on subject property known as 39 Pine Street, North Falmouth, Massachusetts. And should I hold off on the referrals, or do you want to do them now?
Well, you can hold off on them because
Okay.
you have a request. Just remember
Sure.
next meeting to read them.
So, I'll put a note. On behalf of, we received correspondence dated October 18th, 2018 from Attorney Clower. On behalf of the applicant, he requested a continuance, and asked that the board hear the issue at the December 13th meeting.
That was December?
December 13th.
They're in front of the planning board.
So I would,
Oh, okay.
I will move that we, at the request of the applicant, that we continue 078-18 to December 13th, 6:30 here in Town Hall.
Second.
Okay, motion was made by Ken and second by Ed. All those in favor?
Aye.
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 Thank you.
Rapidly moving on.
Okay, up next, we have application 82-18, Packish, 29 Road in Falmouth.
One second.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Massachusetts General Laws, you are hereby notified that Brian Packish of Vineyard Haven, Massachusetts, applied to the Zoning Board of Appeals for a special permit pursuant to Section 240-51A2 and 240-3A of the Code of Falmouth to acknowledge that 3 separate dwelling units existed prior to May 19th, 1959, and to allow a conversion of one dwelling into 2 dwelling units on subject property known as 29 Road, Falmouth, Massachusetts. For referrals, we had, Concom had no comment. Health, 11-bedroom septic system installed, 318. Total bedroom count for all structures should not exceed 11. Engineering, see attached. I will read it, it's a page. This application was reviewed only for impacts to public right-of-ways and public utilities. Nye Road is a public right-of-way in this area. Any connections or alterations to public utilities will require permission from the appropriate town department. One of the plans, which they've attached, has highlighter and notes indicating proposed gravel parking area and existing parking area. If this is a proposed parking area, a driveway permit will be required and a developed plan with more detail will be required. It appears that this proposed parking area is currently used as parking, truck parked there during site visit, and evidence of repeated travel across the grass shoulder. This is a non-conforming driveway. If this application does not receive approval or is withdrawn, we request the applicant come in and file for a driveway permit, which will require a driveway apron and accessibility ramps for the sidewalk. Was the existing parking area added after the survey? There appears to be gravel on the lot as shown on the marked up plans, but this isn't shown on the survey plan. The project must not direct any stormwater runoff to public property, abutters or rights of way. We recommend adding dry wells, rain garden, or other stormwater measure for the roofs. Mass GIS is working with the state 911 department on location-based addressing of structures in the Commonwealth with some assistance from local municipalities. With 3 distinct buildings on this parcel, we recommend that the applicant come into the engineering division so that we may assign house numbers to all 3 units. If this application is approved, we recommend an A and B scheme for the existing dwelling, with 20 being the building number and separate addresses for the other two standalone structures. The address assignments would help local, regional, state, and federal emergency agencies in exactly locating an emergency scene. We have included marked up aerial imagery and plans available in our office, and they list what they've included. Oh, this is probably material. So it's a 1950 aerial, a 1960 aerial, and 1980 registry plan showing 3 dwellings on the lot, and 2018 aerial for current reference. I'm making my way, one sec. Fire department had no comment, planning had no comment, water, may need water upgrades if required. Assessors had no comment. I think that's everything.
And for the applicant?
Mr. Chairman, just for the application, just for disclosure, I own property at 596 Main Street, so as such, I was included in the abutters mailing list. This application doesn't have any impact on that property, so I can be impartial towards the application.
Is there any concern with the applicant regarding that disclosure?
No, sir.
Okay. Anything from the board regarding that?
No.
All right. Okay, and for the applicant?
Good evening. Thank you for my opportunity to apply for this special permit. My name is Brian Backish. I'm the property owner as well as the applicant. Would you like me to speak to the referrals first, or would you like me to talk about the project?
You can
I'm
talk
not sure about the protocol.
You can talk about the project first.
Okay. So I purchased this property in January. Prior to purchasing, I went in and spent some time in the office and looked at some of my options as far as developing the property, its current zoning as business B2, et cetera. My original intention was to develop the property more along lines with my neighboring property, which would be a commercial use with some residential use associated with it. That was the original direction that I thought that I would go. After spending a considerable amount of time on the property this summer, it started to feel to me like a residential path alone would be more appropriate. It's abutted by multiple multifamily. There's some construction of commercial units on abutting properties and things of that nature. But the more I walked the property between the boat to the vineyard and the property, I started to get more of a feel of a residential character, and I decided that it would be a better use for me to pursue a residential use. So with that said, I developed the plans as you see here. There's an existing 4-bedroom home on the property. We added a septic system over the course of the winter. As part of the upgrade, what existed was non-compliant with Title V. At that time, we upgraded to 11 bedrooms. There's currently 8 that exist. I upgraded with the intention of using that additional septic flow for the development reasons I spoke to a little bit earlier. So with that said, I started looking at the project. I started thinking, we have additional lot coverage available, things of that nature. I decided to stay within the footprint of the existing building because I felt that that was more in keeping of the character of the neighborhood. So with that said, we then began to design a project within the building footprint, within the existing structure. And we started to look around the neighborhood from basically the harbor all the way down to Shore Drive and looking at some of the architectural features and things that had been deleted at some time, probably in 1950 or 60 when we got that lovely aluminum siding that's currently on the building. So we added some architectural elements into the plan that you'll see reflected in our treatments of trying to delineate the old porch that was there and create the feel of the era of the house that it really is. So with that said, it's been a pretty long night. I'm happy to answer any specific questions, but to speak to the engineering one specifically, I did reach out to the engineering department upon hearing about their referral, and what I was advised to do was to wait to see how the board ruled and what conditions were added onto the project should it be approved, or if it were denied, and then to circle back and follow back up with engineering at that time. They preferred me to not apply for anything until we were at a point where we were actually ready to move forward. As far as the water line is concerned, we will absolutely need to replace the water line. The one that's there is, I think, a 3/4 inch that's probably from 1920 or 30, somewhere in that range. So upgrading it at the time of construction would make a lot of sense. Board of Health referral was 11 bedrooms, and that's covered in the septic design that you have. So with that said, I'm happy to answer any questions.
Thank you. We'll start with Bob. Any questions, Bob?
No questions.
Paul?
No questions.
Yes, so right now there's, the 2 cottages in the back. Those each have 1 bedroom, is that?
2 bedrooms.
2 bedrooms
please,
each
yes.
in those, okay. And 2 bedrooms. And then how is it, I'm sorry, I don't have the floor plans in front of me. So how is it going to be broken up so it's the front dwelling that you'd be making into a duplex, I guess, or a 2-unit? How is that going to be broken up by bedroom count?
By bedroom count, 1 is a 2 and 1 is a 3.
Okay. 2 bedroom. Okay, so you're really netting 1 bedroom on the property? Okay,
The net gain would be 1 bedroom.
yeah, okay. Do you have a kind of duration of a lease term, or are these currently rented out long-term?
The primary use for me as an individual and my motivation for owning the residential units is for me to actually use them for me and my professional entities pretty much between November and June 1, which is residential purposes. I have people that travel for continuing education. I have a child that travels for school reasons. And I frequently, as you may have heard, the steamship boats have had some slight issues. So with that said, at that time, I spent a lot of nights in the Falmouth Inn, and it seemed prudent that I should have a little bit of a better situation than booking out 4 or 5 rooms at a time. So it's actually it's an interesting situation because for me, I need them in the time of year when most people don't want their homes.
Right.
And when I don't need them is during the summer months, which is obviously a situation that becomes a summer rental. Although we finished construction at the end of July. I've probably spent 25 or 30 nights personally in the home since July.
And then is there designated parking? I know you show kind of expanding the parking. Is there designated parking for each kind of cottage and the units that are going to be up front, or is there free for all?
There certainly will be. The parking change that was referenced in the engineering's referral, we installed a new septic system. There was a whole slew of asphalt that went up in between the cottages. You could actually drive across almost in between and into the back of the cottages on asphalt. And so that's actually exactly where the septic system ended up. So all of that had to be displaced due to that. So without a plan drawn, we didn't really take the time to invest in a major parking area. We cleaned it up, got grass down, and got gravel down to start a conversation. And from there, if there's any preferences, number of spaces, et cetera, we have more than enough land to create those spaces.
Okay. Is there any proposed kind of landscaping, additional landscaping than what's there currently?
Well, there'll be some beautification more than anything, but we're currently screened pretty well. We have a fence that either is property of the neighbor or property that we just recently installed. There is one large tree that probably has to come down. It's in rough shape. I've hired 2 different contractors who have failed to show up to remove it yet. Seems to be a saga that occurs in a lot of places. And that's on the back right corner. My neighbor had asked for it to be removed, and we're working to remove that.
Okay.
But other than that, it's a pretty straightforward. There'll be some beautification. I'd like to have, some plantings around the foundations and things. What was there is simply because it just hadn't been cared for and was overgrown. We did preserve the Japanese maple on the front corner, and we're hoping to keep that as an architectural specimen.
Okay. All right, that's all I had for right now.
Ken, any questions?
So there really isn't any increase in lot coverage. You're proposing a gravel parking area, but in terms of coverage by paving,
No, sir.
Right.
That's one of the things we were trying to be mindful of in not expanding the actual building. We do have some room to stay with below the lot coverage thresholds based on the calculations that your office has helped me
Right.
work through. But with that said, I think it's prudent for us to attempt to use what exists and not expand the intensity of the lot coverage.
Thanks.
Jerry, any questions?
All your parking's gonna be gravel?
Yes, sir.
Good luck. Okay.
Been in
Oh,
the
for-
landscape trade for about 25 years.
Oh, okay.
So we have a means to kind of maintain it a little bit.
Just a tad.
Any other questions, Jerry?
No, thank you.
To address one of the issues brought up in the engineering referral, the question of a stormwater runoff regarding dry wells, would you be amenable to installing dry wells?
Absolutely, I would prefer it, actually.
All right. And then, as you said, you'd be willing to reach out to engineering and address the other outstanding items if we do approve this?
Yes, my conversations with the gentleman there, I'm sorry, I don't have his name handy, but the conversations with the gentleman there, seems like it's a pretty flexible and fluid process, and there was nothing in our conversations that seemed alarming, I think, to either of us.
And you'd be fine if we condition that? just
Sure.
to
He
cover our
actually
bases?
suggested that it would be a condition of an approval should that occur, and that would help him to then have some direction as to what he would need to develop with me.
And just to follow up with what you stated regarding the septic and the Board of Health referral, did the Board of Health referral say it was an 11-bed septic?
Yes.
And you have 7?
I currently have 7. yes.
Currently you have 7, okay.
No, I currently have 8, sorry, sir.
Yeah,
It's
8
going
down,
to 9.
it's going to
And I would go
going
with
to
that.
9, okay. Knew I had something a little off there. All right, that does it from me. Any other questions from the board?
No, I think it's a good project. I watched it as it was being done.
Uh,
It's a Big improvement for the area.
Sari, any questions?
It's not fair. I've known Brian for years, so I will recuse from comments.
Okay. Any questions, comments, concerns from members of the public? All right, back to the board. How would you like to proceed?
I'll move that we close the public hearing.
Second.
Move to close by Kim, second by Ken. All those in favor?
And then I just wanted to comment before, I mean, this isn't a business district, and so I think it's really a great project in terms of kind of being right on the border with the residential and business, and really, I mean, you can see from that, you know, the improvements are really tastefully done. So it seems to be a nice project. And no increase in lot coverage or
Right.
anything, which is really great, so. So with that, I'll move to approve, application 82-8.
Second.
Move to approve by Kim and second by Ed. Moving on to findings.
Oh, I didn't really write much down here.
No increase in lot coverage.
No increase in lot coverage, that there's an 11-bedroom septic, brand new, and proposed 9 bedrooms, and it's only an increase in 1 bedroom total on the property.
Do we care about the impervious or pervious? It's gonna have gravel driveways.
Will be per plan,
That's it.
yeah, that's a finding, well,
Can I ask
It'll
the
be-
board to make a finding on 240-3A, that he's met the criteria of proving that they existed prior to May 19, 1959,
yeah, we should talk about that.
through aerials, and there's information in the file.
I think we were satisfied through the engineering's
Yes.
referral regarding that aspect of the project.
And an old assessor's card, and I believe there's a letter in there as well. So he
Yes, so we make that
satisfies.
finding.
Okay, thank you. And not more detrimental under 240-3C.
Yes. 240-216. Oh, finding amenable to dry walls. Or dry wells.
Dry wells.
I wrote dry wells. And finding that he has met with the engineering department and will work with the engineering department to address, their, or its concerns.
Okay. Okay. Conditions?
Can we include to a finding just of what I said, that this is a business district and, you know, kind of on the cusp of the residential zone, and we find this to be appropriate for that location? And then conditions would be for plans? I know there was some reference to conditioning the
And
engineering
dry wells.
comments too, Suri, I don't know
I'm sorry?
if, I think he referenced that conditioning some of the engineering comments.
On the dry wells, and then the
Yes.
finding was he'll work with him on the other things,
Right.
because he is below lot coverage, so the dry wells is the main thing, and keeping them equal to those.
And you'll work with them on the numbering of the houses, or the buildings.
Yeah,
All
that's
those outstanding.
all
I
of
mean,
that.
well, I guess we're saying per plans, do we want to limit the number of bedrooms? He's got a septic there for 11.
We can,
Well, it's non-conforming, any increase would have to come to you. Well,
But it
no,
doesn't
it
hurt.
wouldn't. It's up to you, you can make a finding that, that the proposed is for a 9-bedroom total on subject property, any increase in bedrooms would come back to the
Sure.
I
board.
think we should. I mean, if-
Yeah.
Is that-
I think that makes
Doesn't hurt
sense.
making it
Perfect.
explicit.
we have a friendly owner now.
Okay, can I ask you to go back? I apologize. 1 second. You stated that it's a building, it's a business district on the cusp of residential, and the proposed
Well, I think in
Is-
keeping is
chose
appropriate.
for
for
residential
the-
use.
and an improved site,
Why make a finding?
right?
Yes.
Yes. You were talking about what we.
Okay, so
Shade
conditions I
away.
have per plans, dry wells, 9 bedrooms
Yeah, and I thought you were.
with any increase before board. Okay. Anything else? Excuse me, I apologize.
I think so. So that motion to approve the project was made by Kim and second by Ed. All those in favor? Congratulations.
Thank you, I appreciate your time. Sari has mentioned that we have a long-standing relationship. I have never worked with her in this capacity or with Ashley, and both were really spectacular, and I learned a lot from your process. I serve as an elected official, so I'm sympathetic to some of the things you have to endure. And I have to say that I learned some things from this process that are helpful in my community as well. Thank you.
Thank you.
Thanks,
you.
Brian.
All right, that takes us to open meeting items. First, we have the minutes from October 11th, 2018. Has everyone had a chance to review those minutes?
Yes.
Any, thank you. Any sort of revisions anyone would like to suggest at this time?
Nope.
All right. Entertain a motion then to approve the minutes.
Make a motion to approve the minutes of October 11th.
Second?
Motion was made by Ed and second by Jerry. All those in favor?
Aye.
Aye.
And I abstain.
Can we take this out of order and do Gifford Street first, please?
Sure.
And then do Vets Park? So I sent you a draft
I don't think we do.
for Gifford Workforce LLC, as requested by the board. Attorney Moynihan drafted, I reviewed, we discussed a couple edits, and I forwarded it to the board, and I've only heard from a few that it was okay, so is there any issues with it?
No.
Does the board want to go forward with an approval of the draft decision as written?
Yes.
Can we vote on that one?
I'd
I
like to
make
make
a motion, we approve the decision as written.
second.
Motion was made by Jerry and second by Paul.
Excuse me?
I think I was on that.
Oh, no, he's on the
Jerry was not
comprehensive.
sitting on that, no, you were on the other one.
I'd like to make a motion to approve the decision as drafted.
Second.
Okay, motion was made by, I'm sorry, Paul, did you?
Paul.
And second by Ed. All those in favor?
That's
Aye.
79-18.
Yep.
Okay, I thank you for that.
Thank you.
I have both of those documents for you to sign tonight. The modification you already approved at the previous hearing, so if Chairman Hurry, when you have a moment, there's 3 decisions in there to sign.
Sure.
And the next one is board review and determination of insubstantial change to comprehensive permit 94-08. That's Veterans Park, Falmouth Housing Corporation. Attorney Moynihan is here to address any questions, and I think because I've had too much coffee, I'll let Attorney Moynihan, if that's okay with the board, explain the situation.
I think
Is
that's
that
fine.
okay?
That's fine.
And this is the letter that Attorney Moynihan submitted. I believe I sent it to all of you, hopefully.
Thank you,
Attorney Moynihan?
Mr. Chairman, members of the board. From a procedural point of view, may I ask who the voting board members are on this matter?
Would be the regular
Be the
five
regular
voting.
voting
Okay.
members.
The regular Joes.
For the record, I am Laura Moynihan, Falmouth attorney, representing the applicant, Falmouth Housing Corporation. Linda Clark is here, the president of the Housing Corporation and executive director. So this is a comprehensive permit that was issued in 2008 for Veterans Park or Schoolhouse Green housing development at 100, what is now known as 100 T-Ticket Highway. It had a number of addresses, 90, 104, 112, and 138. So we've applied under the 40B regulations for a modification to the comprehensive permit. The reason is that after the permit was granted, the sewer system went in, and the town is requiring the applicant to connect to the sewer. So at the time the permit was granted, it was contemplated and discussed by the board, the issue of a sewer connection. At that time, the sewer was at the Stop and Shop, so it was possible to bring the sewer further down T-Ticket Highway to connect to Schoolhouse Green. There's a lot of information at those hearings. The minutes of the hearings reflect that. There's some information in the decision itself, which I filed with the application, about the costs involved in that connecting to the sewer. And the applicant proposed a denitrifying septic system in place of that sewer connection to address the nitrogen removal that the sewer would also offer. So that system was installed. It was an approximate cost of $350,000 to install that system. It is operational now. It's inspected periodically as required. Reports are filed with the Board of Health and the DEP. So the Housing Corporation also has paid for the monitoring of that system. The cost to connect to the sewer would be about $325,000, a significant cost. That requirement to connect to the sewer did not exist when the comprehensive permit was granted, because the sewer did not run in front of or along the street frontage of the development at that time. Since the Little Pond sewer has been put in, now it does. So in 2008, the sewer would have had to have been brought to the development by the applicant. So now the sewer is there. However, there still is a very significant cost involved in the sewer connection, $325,000. In addition to that, the betterment assessment is $141,000 by the town. So we're talking about almost $500,000 for this development to be connected to the sewer. Granted, that betterment can be paid over 30 years, but that's the betterment that's been proposed. So the applicant is, as a result, asking the board to grant a waiver from the local sewer bylaw that says that if the sewer runs in front of your property, that you have to connect to it. This system is working fine. At some point, the system will fail, and the Housing Corporation is proposing that if the system fails, or by 2026, which is 8 years from now, whichever occurs first, it will connect to the sewer. But what that will do is allow the Housing Corporation 8 years to essentially save for the cost of this connection. They don't have the money right now. And some people might say, well, can you go out and borrow it? Can you find the money? Well, maybe, but We don't have it now. And to do that, really, I think is taking valuable resources away from the development of affordable housing. When we have a system in place that's in perfectly good working order, it is a denitrifying septic system. It was accepted at the time in 2008, rather than requiring this substantial cost to bring the sewer down to the development. So we've asked you to consider and approve this as an insubstantial change, meaning that it could be done administratively by the board without a public hearing. So since we've been visiting you fairly frequently these days, I thought it might be helpful to say, or just speak for a minute on why a public hearing would not be required or really not necessary here. By that I mean if the board felt, well, we don't feel it's insubstantial, we think it's substantial, we think there should be a full public hearing. We don't think there should be. We think it's an issue, and the reason for that is because there was a public hearing on it. There was a public hearing on it in 2008, when the whole issue was discussed about connecting this development to the sewer. The differences between proposing the denitrifying septic system, the costs of that system, the monitoring that would be required, there are conditions in the permit, versus the cost of the sewer connection, which are comparable. Even though here it's running out in front, we still have to connect to it, and we have to pay the betterment. There it was bringing it down from the Stop and Shop. The ZBA found in the comprehensive permit that the development with the DNITE system does not endanger the public health or safety of or the environment. There were conditions for monitoring. There was testimony on the engineer on the performance of the system. And there was consideration of the cost of connections versus the expenses of the DNITE system. So those are all the things that were already hashed out at a public hearing. So that's why I think that this is something that the board could deem to be an insubstantial change and assist the development here by granting that waiver, allowing this system to remain as a denitrifying septic system in place, subject to the monitoring requirements for 8 years until 2026 or until failure. That's the estimated life of the system. Okay, thank you.
Thank you, Attorney Monahan.
Can we ask questions?
I was just about to ask, any questions from the board to Attorney Monahan? Or?
So I had one. You said the system is currently being monitored. What are the performance specs?
Well, it varies. I mean, they're monitoring, they're doing the DEP quarterly reports that have to go to the Board of Health.
But do you know how many milligrams per liter it's releasing? No.
No. I mean, those, at the time, the system was 2009 BSS design. He said that the BioClear is 4.9 parts per million when all factors are taken into account, including total nitrates and total water. At the time, there is a condition in the permit that has the, I believe it's 12 milligrams.
Okay.
And the septic system shall be consistent with the applicant's proposal to achieve nitrogen concentrations of 12 milligrams per liter or less on a yearly average basis. Monitoring of the system shall be consistent with any requirements as may be necessary by the Board of Health.
Right. But
So
as
that
far as
was-
you know, they're in compliance with that standard?
I can't really testify on, to that. I haven't evaluated it to that level. I mean, I think our request would be, you know, we're dealing with this on a cost basis alone, so.
Right. I'm just trying to assess that against the,
If there was an issue, the Board of Health would have notified the applicant, because it is being maintained and checked quarterly.
right.
Yeah.
So that was really my question, was whether you've gotten any negative feedback from, I guess, the Board of Health. or whoever would give you the negative feedback.
I'm not aware of any. Have you, Linda's here, have you received any notices from the Board of Health? Okay, so,
They do monitor and I have not.
Yeah.
okay.
Question?
Sure.
I think it's insignificant change, only because there's a 40B that gives you a pathway to avoid tying in and avoid a local bylaw. I would urge you to check with the state to make sure, I don't think the state would
Your
say
determination.
you would have to connect because you have an existing septic tank, and they would probably say upon failure, you would have to connect. But that's a state issue, and you should get clarification from DEP.
In the event of failure, they will have to hook up. We all know that.
Well, and
Well, no, even now, they should check.
We sit, the board sits in judgment. This is based on the flow neutral bylaw and the 40B
And I'm
regulations.
basing it on Title V, and I'm saying it's to their benefit to check with DEP, because we could waiver, not waiver it, give you the time extension. But our bylaw was an extension of DEP bylaw. Okay, so I mean, there is, I'm not holding it up, I'm just giving it as an advice.
right, and the Housing Corporation really is looking for time here. The 8-year time limit is the issue, because they have invested a substantial amount of money in the existing system that was approved by the Board of Appeals.
Yeah.
And so to require them now to hook up and pay another $325,000 plus $141,000 in a betterment, that's a hardship that, and I think the main point is that it was contemplated at the time this permit was granted that the sewer could have been available to the development if these costs were deemed to be economic for the applicant as part of the 40B process. So as it turned out, the denitrifying septic system was less expensive than the sewer hookup, and the board approved that. And that's really the crucial point here. They're not trying to avoid the sewer hookup forever. They're just looking for that additional leeway to continue to operate this system, as it is now until 2026, or there is a failure, then it would have to hook up in either case. That's it.
Kim, I think you had a question?
Oh,
Or,
yeah, I was gonna have a question, but I just think it would amount to economic waste if we just said this denitrification system that's still good, that by all accounts is still operating fine, it's satisfying criteria, and we just had you put it in. Seems wasteful. So use it and then use the extra time to your benefit and,
well said. Any other questions from the board for Attorney Monahan?
No.
So use it up till it craps out.
So I will move that this is an insubstantial modification. Unsubstantial?
Second.
Ew.
Insubstantial.
Insubstantial modification.
I think we want to, if we could just include in the motion, explicit statement of the fact that it's insubstantial because they have invested in a denitrification
Sure.
system.
Did you get that?
Do you want to make that motion, Ken?
I'm happy to make that.
Okay.
Do you add
And I'll
on the 8 years of failure?
I'll second it. Yeah, I think,
Yeah,
I mean,
and,
it's-
and because they have agreed that within 8 years, or if the system fails prior to that, it will be replaced.
Yes.
Yeah, so those are two important caveats that,
All right, so Ken made the motion and Kimberly seconded?
Yes.
Is that what I heard?
All those in favor?
Aye.
Aye.
5-0. Thank you, ladies.
Thank you.
Thank you.
Just to clarify, it wasn't that the system would be replaced in 8 years, that they would connect to the sewer.
Right.
Okay, is that clear?
well, I presume
Yes.
if they're connected to the sewers, they're not using the system, is that correct?
Yeah, for downspouts.
Right,
And do that.
just want to make sure that you understand. They will connect, yeah.
Right.
Okay, thank you very much.
Thank you, Attorney Monahan. Okay, moving along with our open meeting items, board updates.
Can I just thank Laura for
Oh, yes.
helping with those decisions
Yes.
that I'd
Thank you.
still be working
you.
on?
That can be an official board update then. Thank you, Attorney
Thank you.
Moynihan.
I appreciate it very much.
Okay, procedural rules and policies?
I owe you these, and since
you
I'm
gonna
up
get 'em?
against the deadline, I will get them to you. I do have them set aside, just need to work on stuff out. So it will be done, it will be Cerie's parting, legacy there.
You can bring them to La
Bronze them.
Cucina.
Yeah, her retirement party. Would be a pretty lame gift.
Any future agenda items? Okay, seeing none, meeting adjourned.